This program is brought to you by Emory University.
We're live streaming this event, so we need everybody to kind of settle down and be quiet at this time. I just want to thank my office, the Supreme Court Committee on Justice for Children, for help organizing this event, as well as the Barton Center for Child Law and Policy. We really appreciate having these opportunities to gather stakeholders together to talk about these critical issues in child welfare law. Just a few housekeeping things. Please turn off your cell phones, mobile devices. I will judge you if I hear your phone. No, just kidding. This program is going to conclude today at 3:15. We may finish a little bit before that, and a 10-minute break will be announced partway through the program. Make sure you have registered at the table in the hallway, pick up materials, and sign for any CLE credits if you need them. If you didn't get a chance to register, make sure you do so at the break. A program evaluation will be given out at the break. In order to receive your parking validation, please complete the evaluation and return it to Michelle at the registration table at the conclusion of the program. So don't get too hasty with filling out those evaluations. Evaluation results will help us to guide what the conversations will be in future legal academies. Certifications will be available at the end of the program only for those who have pre-registered online at the registration table. So for those of you who registered today, you'll have to get your certificate at a later date. Parking validations are good for 3 hours of parking only. If you remain in the deck longer than 3 hours, you must pay the difference of parking cost. This doesn't apply. Restrooms are located outside there, and please make sure that you recycle your recyclable items. Okay, I'm just really excited to turn the table over to our visiting scholar, Judge Rawlings, who was a former juvenile court judge and also was the state child advocate. And he just told me some really exciting news that he is enrolled in a master's program at Oxford University to study international human rights in the fall. So it's very exciting. And his bio is on the back of your handout that you got, so you can read further about Judge Rawlings. So now just welcome him.
Thanks. I'm not feeling too well, so I think Araceli is going to do this whole presentation for me, right? Yeah. Good afternoon, everybody. First of all, before we start, I want you to feel free to get up and get more food. Don't, you know, there's free food back there. You might as well enjoy it while you can. Number two, the next time you have a lunch, I want to tell you where I had lunch today, and I think you should all go there. Who knows where the Mexican consulate is? It's on Chantilly Drive, kind of like behind, is that Cheshire Bridge, or what is that, Jim? Okay. Yeah. So anyway, it's kind of fronts on 85. If you go to the parking lot on a sunny day, they have a lady who sells the best tacos and gorditas and stuff like that. So I highly recommend it that you stop there and grab you one day. So we're going to talk today about discretionary appeals from juvenile court, especially on TPR cases. And that's kind of a narrow subject, you might say. So where on earth did you come up with the idea of talking about this? And of course, why is it something that we should care about, or something that should be the subject of one of the child welfare legal academies? Well, this talk actually evolved out of a conversation I had with a juvenile court judge who will remain nameless, and the basic statement was, what are they doing up there at the Court of Appeals? Now, let me kind of tell you, I was juvenile court judge, as y'all know. I was also a Court of Appeals staff attorney for several years. And so I take perhaps a little bit different approach to looking at these cases. But I thought it was probably a good time to think about how we are dealing with termination of parental rights cases in general, especially those, we're talking specifically about juvenile court, TPR cases. And we've also had in place for the last, since first 2008, we've had in place what used to be a direct appeal from those cases in juvenile court. And in 2008, We changed that so that any TPR filed after that date would be handled, the appeal from it would be handled via a discretionary appeal process. So it's a good time to sort of see how that process has fleshed out over the last few years. We've got at least 5 good years of information under our belts and experience with that law. And also kind of look at it in the bigger context of what are we doing on appeals, what's the purpose of our process for that, how is that process working, and of course with the bottom line being what we want is a combination approach. We want for children who need permanency to experience that permanency as quickly as possible. But we also understand, and I can't emphasize enough, that families have a due process right to be together. There is an interest in family togetherness, and that really is a fundamental right, as we all understand. So let's go back to the past a little bit. If you look at, say, 2005, 2008 data, every year, that was back when TPR appeals were direct, okay? So how does that process work? Some of you who are not, perhaps not as familiar with these cases on a day-to-day basis, as you know, TPR in juvenile court, if it's contested, is often a bitter fight. These cases are often handled over the course of several different days of hearings, oftentimes split, from one week to the next, depending on the judge or depending on the court. If you are out in certain parts of Georgia, the judge may only be there one day, and so you may have to continue the case to the next week. So once you finally had a decision, you, of course, representing your client, because we have had a good tradition at least of ensuring, even back then, that parents in TPR juvenile court cases had attorneys. The parent might say, well, let's appeal. Could be the father appealing, could be the mother appealing, could be both. Of course, there are certain times, I guess, when the child might appeal, but we're generally looking at parental attorney appeals. And the Court of Appeals between 2005 and 2008 published about 50 decisions on those appeals. We're going to come back in a little bit and talk about what was in those decisions. But in general, the reversal rate was about 12% in published decisions. Now we know that there were numerous appeals that were probably done as a Rule 36 affirmance, and we don't have access to those right now. The data's a little old. Perhaps I could get John Ruggieri at the court to go back and dig it up. Quite frankly, it was a little too much trouble for what we're doing here today. But we did have some data from back then. It took 303 days on average, a little less than a year, from the notice of the appeal to the final judgment at the Court of Appeals. Now, of course, there are some that went on to the Supreme Court. We can kind of dismiss those. Those are kind of outliers unless Jim Outland was involved, in which case they went to the Supreme Court. And what you often saw were blanket statements of the law. A great deference to the juvenile court. I want to kind of come back in a little while and talk about what those statements were, how the cases were approached, how the cases were handled. But I want to kind of start you off with the idea that it appears to me that back then those cases were often treated as fairly routine. Now, for those of you who may be on the Court of Appeals listening or watching this later, I don't mean any disrespect by that. What I mean is this. You're talking about the busiest intermediate appellate court in the country, and you have case after case after case coming through your doors. You've got to read all of these transcripts. You've got your staff attorneys to go over it. But the truth is, sometimes you get cases and you feel like you've heard this case before, right? We probably do that in private practice as well. So I think there is a danger when you're on an appellate court of getting to the point where certain types of cases feel a little routine, and they may be handled as a routine appeal that must be disposed of, and may not, because it's a direct appeal, for example, from a criminal case, may not get as much attention as other cases that appear to be, quite frankly, more interesting. So we're going to come back to that thought in a little while, and presumably the Court of Appeals will not throw me out of its bar between now and then. So one of the things, of course, we think about is the time from TPR to adoption, okay? And we have pretty good data on this, all this data, and you've got a paper here, you can read all this stuff at your leisure when you're having insomnia. But from October 2004 through September 2005, for example, there were a little over 1,200 adoptions. The median time, not the average time, but the median time, from the TPR ruling to the adoption was 10.3 months, okay? Now, obviously, the vast majority of those were not appealed. Think about, if we had 50 published opinions in a given year back then, and you had 1,213 adoptions following TPRs, then the vast majority of those are neither contested, somebody surrendered their rights in juvenile court, and it proceeded forward, and then there was fairly quickly an adoption. And then in October 2007 to September 2008, it actually got better, not down to 9 months. So we're talking about a situation overall where the juvenile court and then the superior court generally is working fairly quickly to move these cases from the TPR ruling to the final adoption for the child, which is what we want them to do. So why did we suddenly get a focus on these time frames anyway? Well, a lot of it, of course, had to do with the Adoption and Safe Families Act. How many of you were practicing law in 1997 when the Adoption and Safe Families Act came along? At least one of you. I'm sure if you don't want to answer that question, it's okay too. I think I was practicing some sort of insurance defense law maybe. Actually, I was at the Court of Appeals then. So I wasn't really affected by this, but I understand that from those who were practicing back then, that this was there was a fairly significant change in philosophy about that time for children in foster care. We had really throughout, I think, the 1980s, early 90s, we'd had a concern that began to grow that children were drifting through foster care without ever getting a permanent family. And of course, we still have that problem to some extent. But the Congress, of course, controls most of the federal funding for foster care, and as a result, they, from time to time, enact federal laws that say, we are only going to give you your federal funding for foster care if you follow our directions. So one of the things that they decided to do in 1997 with ASFA was to give incentives to speed up permanency for children, but in reality, they're disincentives. If you don't do things quickly, we will take away your 4E federal foster care funding or reduce it. And that, of course, is an ongoing issue and continues to be something that DFACS and the juvenile courts are very concerned about. But the new rule said that if a child has been in care for 15 of the most recent 22 months, DFACS in most cases, unless there is a compelling reason to do otherwise, must file a petition for termination of parental rights. That in Georgia was incorporated into what was at that time OCGA 151158M, and it's now pretty much been moved almost intact to OCGA 1511-233A1. So, what happens then? Suddenly, to comply with the federal and state law, you have a new incentive to get these cases moving through TPR. And then, of course, what do you do after TPR? I'd say in most of the cases, you're doing the TPR so that the child can have an adoptive placement. So there was a push all over the country to do this, of course, as you can imagine. And in fact, it certainly has worked. I mean, so for example, when you look at from the time of removal by defects in the juvenile court to the TPR hearing, okay? In 2003, the median number of months was 23.4, and we've gotten that down to 17.4 months now. So we're doing that a lot quicker. We're moving things along much more quickly. Of course, we now have, especially with our new juvenile code, but certainly through the federal incentives as well, we are trying to do permanency as quickly as possible, whether it's reunification or placement with a guardian or a relative or TPR and adoption. At the same time in the early 2000s, mid-2000s, a lot of scholars and courts, and I've cited some of the articles in the paper, also began focusing on how we might expedite appeals in these appeals. Expedite not only the TPR case itself, but also expedite the ruling if the case were appealed. So it's not enough to simply say, well, we have a TPR. You've also got to say, well, the parent's got a right to appeal this, right? So we need to get that done quickly too. And there are a number of articles, a number of organizations that published information on this and that started movements to attempt to get those TPRs done quickly. One of the things we did locally, I think you're all familiar, of course, with our Supreme Court Committee on Justice for Children, which is our federally funded court improvement project. It's run by Michelle Barkley and chaired by Justice Hines at the Supreme Court. And one of the things that they have attempted to do over the years is make improvements in our judicial process and our judicial procedures throughout the state. And in the mid-2000s, they came out with a report that began to look at the delay in permanency caused by the fact that appeals were not moving quickly. In fact, if you look on the website, there's still a report up from about 2006 there, 2007. Remember, the internet saves everything, so be careful what you put on the internet, including this presentation. When parent-child relationships remain in legal limbo, parents are unable to provide security and stability for a developing child. And they said the appeal process, as we all know, means that families and children must put their lives on hold. Now, that issue having been brought to the public attention, to the attention of legislators, the result in 2007, the legislative session then, was House Bill 369. This was a bill that Jim may have had some writing. Did you have something to do with writing that bill? Because it actually did a lot of changes to just general child custody law. But at the same time, it made one very significant change, which is that it took the termination of parental rights appeal from juvenile court out of the direct appeal and put it in the discretionary appeal. Okay? Interestingly, the finding of deprivation or dependency is still directly appealable. And I think we haven't gotten into this, but I think you've actually seen an increase in those appeals. So, the intentions. Well, the intentions were good. The idea, of course, was to reduce the number of unnecessary appeals because, as we know, the Court of Appeals grants these discretionary appeals pursuant to its rules only where either there's error apparent from the application or where the establishment of precedent is desirable. The intention was, of course, at the same time to reduce time to permanency. The thought was, this is how it generally is supposed to work. You've got to file an application for discretionary appeal within 30 days of the decision, the judge's entered decision on TPR, and then takes a few days to docket that and everything. But within 30 days of docketing, the court should have that decided. And I think that's been the case. The court has certainly done a good job of turning around those discretionary appeals in an appropriate time frame. And the whole idea, of course, was, well, 60 days is a whole lot shorter than a year, right? So think about it from the standpoint of an attorney who represents a parent, for example, and says, well, I need, my client really wants me to appeal this. If I had to do if it's a direct appeal, I'm going to feel compelled to go ahead and file something, and then we got to go through this whole year-long process. But if you do an application, everybody can feel a little better, because if it's a valid appeal, then it goes up. And if it's not a valid appeal, then the Court of Appeals shoots it down, and perhaps everybody can go on, and this child can get permanency, and the whole world is happy. Has it worked? I think that's question number one. Well, I guess you'd have to say it has if the purpose was to cut down on the number of appeals. Certainly, the granted discretionary appeals are way down over what we had before. So, as I said earlier, back in the, say, early 2000s, there were an average of 50 published decisions annually. So we can imagine, I don't have the numbers specifically, but we can imagine there were another, say, 30 unpublished decisions on top of that, or maybe 50. You're talking about 50 to 100 appeals in these TPR cases each year, right? Now, since 2010, which is certainly the first year we've had almost nothing but discretionary appeals, and I'll get back to that in a minute, you've got a total of 109 granted applications for appeal, or an average of 22 a year. Okay? So from, say, 100 a year down, or 75 a year, down to 22 a year, that's a pretty significant decrease. But interestingly, because these appeals are a small subset of all of the juvenile court TPRs that proceed to adoption, it really has not changed the median time to adoption. It was 9 months in 2007, 2008 with 1,000 adoptions that year. In 2013 and 2014, there were a total of 811 juvenile court-based adoptions, and it took 9.8 months from the time of the court's TPR ruling to the final adoption. So it's actually gone back up. Why is that? I don't know. Maybe one of y'all can tell me that when we get down to the end of this. I would say this. I don't know that it's statistically significant, the difference between 9 months and 9.8 months. Okay? Now, as I said, it's a little difficult to compare apples to apples here, given that we don't have a lot of information about unpublished decisions back prior to the discretionary appeal process. But there were 304 discretionary applications filed between 2010 and 2014. The applications were ruled on in an average of 22.8 days. Okay? So, that's a pretty quick turnaround. It means that, if you're only they've granted basically 32% of the overall applications during that time period. So it means that at least 2/3 of these TPR rulings have been finalized the contested appealed TPR rulings have been finalized within about 50 to 60 days after the court's TPR ruled, freeing the personnel, the attorneys, the judge, the guardian ad litem, freeing everybody up to do more work, and also freeing the child up so the child could get moved on to permanency. The other interesting thing, and I think some of y'all came in a little later, so I was just saying that one of the things that sort of began this conversation that turned into this presentation was the comment from a juvenile court judge essentially to the effect of, what on earth is the Court of Appeals doing? It wasn't a question so much as a comment, of somewhat a frustrated comment. And part of that is this: between 2010 and now, if you look at the TPR, juvenile court TPR appeals that have gone up, that have been granted, and in which the Court of Appeals has published a decision, the reversal rate is 50%. Okay? So in other words, to the average lawyer or the average judge who is simply going through the Fulton County Daily Report or Westlaw or whatever and reading Georgia Court of Appeals TPR cases, your first reaction is, these folks are just reversing the heck out of everything. Right? Feels like that to a lot of folks, I know. And I do think that is sort of the impression that is out there on the street, is that the Court of Appeals is in great disagreement with the juvenile courts as to how to handle these TPR cases and what is important and what factors matter and what evidence is required. But, and you kind of have to take my word for this because I can't explain everything I did in looking at all the data. But I tried to basically figure out, and I looked at all of the granted appeals, all of the dismissed appeals over all these years, and if you look at the overall rate, okay? So, to explain that a little better, remember I said that before 2008, back during that time frame, if you looked at the published opinions, the reversal rate was about 12% in TPR cases. If you look now at all of the applications that were filed between 2010 and now, and then if you consider that the only ones that were published were those that were either considered more important or were reversed, then the reversal rate remains at 12%. So in other words, the change in the process, to some extent, has us as the consuming bar, not the alcohol consuming bar, but the bar of consuming lawyers, feeling as if the reversal rate has dramatically increased, when what is happening is that we're not able to see, because they're not published, all of those applications for appeal that have gone up to the Court of Appeals and have been quickly shot down. Okay? Whoops. Now, again, on the issue of has the discretionary appeal process worked? Well, so if the intention was to speed up permanency and cut down on the number of appeals that were considered without merit, I think you'd have to say that it's worked. We're down to having only about 22 or 23 cases each year that are considered significant enough by the Court of Appeals that they're actually taken up and an entire year is spent getting the transcript together, getting the record together, awaiting an opinion from the Court of Appeals, and having that decision come down. Okay? So, if in a year we have 800, say, cases that move from TPR to adoption, and only 22 of those, or just say 30, okay, are taking a long, long time, then certainly the process has resulted in an improvement in time and in a more efficient use of attorney resources and of court resources. Because how many of y'all have had to deal with appeals on TPR cases? Do y'all like spending a year waiting for a decision? Okay, think about it. There's a lot more that y'all can be doing as well. And of course, for the children involved, it means that if your appeal is not granted, if the parent's appeal is not granted, then you're going to get permanency a lot quicker than you would otherwise. And you don't have to sit there and say, I'm getting so used to this foster family, or this pre-adoptive family cares for me so much, and then one day, a year later, you're back at square one, right? A couple of problems, though, that have been noted with this process by various practitioners who shall remain nameless. The one thing is that when you do an application for discretionary appeal, who's done those? Okay. Let me just throw out questions, and I'll repeat it for the video here. But what did you put? How many of you had a transcript to go with your application? Okay. I'm not seeing anybody raise their hands. I did an informal survey, and some were able to get a transcript. But normally when you do an application for appeal, you're going on the order that the court has written and on whatever else kind of documents and allegations you can come up with. Maybe a case plan, maybe another order, maybe an affidavit. You might have, as I did in my last case, a letter that we use as an exhibit. But does that application completely represent the entire record? It can't. And although all of us who, whether we're parents, attorneys, children's attorneys, state attorneys, or whatnot, although we all understand, recognize, and appreciate our duty of candor to the court, we are also advocates. So we just by nature, when we feel that we've got an issue to appeal, if we file an application for appeal, we're going to emphasize our facts and not necessarily the other party's facts. Which means that if we're really good at writing applications, in other words, if we're really good at BSing, or to put it in a kinder way, if we're very persuasive individuals and truly believe in our case, we might very well be able to get the Court of Appeals to grant that application on the strength of what we have given the court, but without the court having the benefit of the full transcript. Now, back in the olden days, i.e. before the discretionary appeals process, when you filed your enumeration errors, your appellate brief, you had the transcript there, and what's the first thing that happened? The other side filed a response that said, this is crazy because look at page 12, record page 2, transcript page 131, line 3. Okay? So The question, of course, is why does especially in the state cases, why does the Attorney General's office not respond to applications for appeal? I think a lot of practitioners have suggested to me that they're concerned that the Court of Appeals is getting a one-sided view of the facts. Because what you want when the Court of Appeals is considering, think about it, the Court of Appeals is considering the following in most cases. A child who is probably in a pre-adoptive home, who the foster parents are ready to adopt once the TPR is final. The Court of Appeals is considering when looking at the application whether that child is going to sit in limbo for another 300 days. Okay? But yet, when we do our appeals, and we do our application for appeal, and no one responds to the application for appeal, oftentimes, and of course sometimes it happens, but you may not have a response from the state, you may not have a response from the child's attorney, you may not have a response from another party. All you've got is a one-sided application. And I think that's problematic. Now, what we want to do is, I got couple more slides here. I'm going to kind of set this up. I'm going to go ahead and take a break after this slide for about 10 minutes because I want to kind of get after this into the meat of the cases. Let me tell you first what we had hoped to do and what I hope we'll be able to do in the future and what we actually were able to do. The original idea was to go in, and we know, for example, that the Court of Appeals received in, say, 2014, I believe it was 63 applications for appeal, and only granted about 22 of those. Okay? So our original plan with this project was to go and read every single one of those applications and just see what's in them. Because how many of you have, during your recent career practice or CLE, how many of you have ever had a good class on how to do an application for appeal? Application, anybody? Mary Hines, who was a clerk with me at the Court of Appeals, and I did one 20 years ago, and it's the only one I've ever heard of. So it would be helpful to see in these applications what is being filed. What kind of responses, if any, we don't believe any are being filed, what kind of responses are being filed to the applications, and what makes up a good application for appeal. But unfortunately, we were not able to get that, and I'll come back to the reasons for that later. So what I did instead is we reviewed all of the 50 or some odd TPR opinions that had been published since 2010. Some of those were focused on simply things like service of process on a putative father. And those are legal issues. They're dealt with by the law. But as we all know, the ones that perhaps are most difficult for the court, because they were also difficult for the juvenile court and also difficult for the attorneys involved, are those involving our four-factor test, which is now under 1511.310A5. We know that in the vast majority of contested TPR appeals, there are four significant factors that the court has to decide before making the decision of whether there is such clear and convincing evidence of parental ability or misconduct that the bond between the child and the parent must be severed. And those four factors are that the child is dependent or deprived, if you want to use the old term, that the parent is the cause of the dependence, that the dependence or deprivation is likely to continue or will likely not be remedied in the foreseeable future, and that the continued dependency or deprivation will cause or is very likely to cause the child serious physical, mental, emotional, or moral harm. And then, of course, after that, we make the best interests of the child thing is whether or not it's in the child's best interest to have the termination go forth so the child can be freed for a permanent home, perhaps with an adoptive family. But these four factors are what, for 20 years certainly, have been the real battleground on these contested TPR cases. And after we take a real quick break right now, I'm going to come back and talk about how the court used to treat these factors and how I see the court treating those factors in current cases. Thank you all.